Okay, we'll start. My name is Poornima Hatti and I lead the disputes practice at Samvad Partners. I'm based out of Bangalore. It's my privilege to speak to you today on the Code on Wages Bill 2017 that is now before the Parliament. My partner in Delhi, Junaira Rahman, will also be joining in and is a panelist on today's webinar. Junaira is based in Delhi, so we're both speaking from two different locations. So please bear with us. If there is a little bit of a lag in terms of communication. If you wish to ask any questions, you will see a questions sort of window on the Zoom technology. Please feel free to type in something there and we'll try and take them along as we speak, if it doesn't interrupt the flow of the conversation. If we can't do so while we, during the course of the presentation, one of us will try and answer them towards the very end. We hope to wrap this presentation up within half an hour to 40 minutes, so we get about 10 minutes to have a conversation at the end. If you can hear me clearly, that should be fine. If you can't, please again type into so that I can understand that people cannot hear either Junaira or me. I've shared some slides. These should also be visible on your screen. So we'll start from there. Am I audible? If somebody could say yes or no, then I'll start from there.
Thank you, Poornima. Junaira here. Good afternoon, everyone who's joined us for the discussions today. Like Poornima mentioned, we'll just be taking you through some of the relevant provisions that have been incorporated into the Code of Wages, and we'll try and tell you what are the specific changes vis-a-vis the current wage legislations that we have today, with emphasis on the impact that this is likely to have on stakeholders.
Thank you, Junaira. So if you see the set of slides, the first slide that we really want to outline what we are going to be talking to you today about. As of yesterday, the new Home Minister, as well as a bunch of senior cabinet ministers, met to talk about the current wage code bill, which is still pending. And as we understand it, this, along with the bill on occupational safety, is high on priority for the new government. What we are trying to discuss today is whether, in what form will this bill come into play. The government currently does not have a majority in the Rajya Sabha, but from where we see it, this is going to be something that can get resolved in the coming years. And experts say by 2020, this bill or a variation of the form of the Code of Wages should come into play. There is a standing committee report of this that has been very, very useful, and there are lots of comments that have gone into this from that perspective. So this also adds to the discussion that is before us today. What is the Wages Code? The Wages Code is something basically looking to consolidate 4 existing laws: the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act into one consolidated law. Anybody who practiced labor law or is on the HR side of things will understand the high degree of compliance that Indian labor law requires. So this is sort of an effort by the government to say, simplify this compliance regulations. There are various definitions under each of these laws which do not necessarily tally. So this is an effort to sort of make it one single consolidated law insofar as payment of wages and payment of bonus is concerned. So that's really the objective. This bill is still pending in the Lok Sabha. What we'll do is we'll discuss a little bit of the current status, some key concepts. We'll be looking at what does wages mean, what does bonus mean, changes in the definition of employer, employee, workman. These are ideas that are often discussed and litigated in India. We look at the proposed changes sort of in a comparative context, comparing it to the existing wage legislation. And in some sense, we'll do a little bit of navel gazing to say, these are the potential impacts on employers, and what are the compliance requirements that we're really looking at. So if you now move to the next slide, which really talks about the overview of these 4 acts, you'll see that all four of those acts are now will be replaced to a single comprehensive code. So these wage legislations will then stand repealed, and you will have the Code on Wages 2017 as it was then introduced, which will have 68 sections and 4 schedules that will come into play. The objective of the wage code on the next slide, Junaira, will you take that up, please?
So essentially, the wage code has been formulated basis recommendations of the Second National Labour Commission in 2002, where they came up with a suggestion that almost 44 central labour legislations in India should be codified into codes on the basis of functionality, and the Code on Wages is one of them. The primary objective is, like Poornima mentioned, is to simplify the laws. And right now, you need to actually refer to 4 separate central legislations to kind of understand the terms of payment of wages or the payment of bonus. So the essential objective is to bring everything under a single code. They're trying to provide for uniform definitions for same terms which are used in these 4 legislations. For instance, wage is defined separately in the Wages Act and the Bonus Act. So they're trying to bring everything under the same umbrella. One important thing that they're trying to, in fact, the most important aspect of this code is that they're seeking to universalize the right to receive minimum wages to every employee. So right now, currently, minimum wage is payable to scheduled employments only. So the code goes ahead and says that proposes that minimum wage will be paid to every employee, irrespective of how much he or she is earning, and to both the organized and the unorganized sector. And it's sought to bring about some amount of digitalization, where maintenance of records, etc. There's a proposal that it would be maintained in digital form. Then they've also sought to bring about this whole concept of a facilitator who will act as an interface between employers and employees, reducing the number of authorities that right now you need to go back to under these 4 legislations. Another aspect that they've tried to address is, so currently minimum wage is determined based on, determined by state government. So every state has a different wage. So there is a lot of disparity. So what the wages code is seeking to propose is that there would be a national minimum wage, which will be formulated by the central government, and no state notified minimum wage can be below the national minimum wage. And lastly, importantly, another aspect is that they've sought to bring about equality in terms of fixing wages and payment of wages amongst genders, irrespective of the kind of work you're doing. It doesn't matter if you're between genders, there would be no disparity in fixing wages. So then we'll quickly talk about the status where we are right now. So the wages code was introduced in the Lok Sabha in 2017. On the 21st of August 2017, it was referred to the Parliamentary Standing Committee, who gave its report in December last year. Now it is likely to be introduced in the Lok Sabha in the upcoming session in July. What we understand is that, as Poornima mentioned right up front, once the Lok Sabha approves it, the Rajya Sabha will need to approve it, and then it will require President's assent to become law. And what we understand basis news reports today is that this is one of the major labor reforms that the government is seeking to implement as soon as possible, and it is likely that this is going to be law in, say, a year from today. Moving on to some key concepts that have been introduced under the wages code. Some of these provisions, of course, are there in the current legislations, But the wages code has sought to amend some of these concepts. And one important aspect is with respect to employee. So the scope of an employee has been significantly widened under the wages code, making the code applicable to a larger section of people. So essentially, an employee right now under the code would be any person who is engaged for wages in an establishment, which is also has a very broad connotation to do any skilled, semi-skilled or unskilled, manual, operational, technical, supervisory, managerial, administrative, or clerical work. So it's essentially bringing even the concepts of a workman into the definition of employee, making the ambit very large. The concept of a worker still continues to be defined under the wages code, but what we've seen is that the reference to workers is only used in the context of resolving industrial disputes. Otherwise, the code applies to anyone termed as an employee, which is very, very broad right now. Moving on, we've spoken about who an employer is. Here again, the definition of employer includes any person who employs at least one or more employee in an establishment. So this is a significant change again from the current legislations, where we have, a minimum number of people who need to be employed in an establishment, most of the labor laws to apply. But that has kind of been done away with. Even if you're employing one person who is within the scope of an employee, you are an establishment within the code and you're an employer. So this kind of brings into purview even your sole proprietorships, etc., who are within the scope of an employer.
So before we go into the next slide on what constitutes an establishment, it's interesting to note that when we compare the new code to the existing act, the definition of worker which exists under the new code is sort of similar to the existing definition of workman under the Industrial Disputes Act. So that is really the comparative sort of scale. And if you look at the definition of employee, it brings in the new words managerial. So it then opens up who is a manager, even into terms of senior management, and brings into the definition of the code people who would have otherwise not been included. Of course, the Industrial Disputes Act continues to exist, and that's not something that this code seeks to replace. So that continues to govern industrial disputes, and this code also talks about what constitutes an industrial dispute, inter se between an employer-employee, as well as between two different kind of employers. I'm now moving on to the new slide, which talks about an establishment. The establishment definition sort of hasn't changed really. It continues to be any place where any industry, trade, business, manufacture, or occupation is carried out, effectively now extending the statutory framework for minimum wages and payment of bonus to both the organized and unorganized sector. Just in terms of sheer numbers, we are looking at more than 42 crores of people being adding on to this whole regime of payment of wages. 48 crores, I'm sorry, and out of which about 82% will now fall within the unorganized sector. So it's not the whole idea of what kind of money that will be of an impact through these sort of codes coming into play is interesting. We've put out the definition there of same work or work of similar nature. The Standing Committee report talks a lot about minimum wages have to be defined for different people differently, which means that until now there was no minimum wages that sort of differentiated between people who had experience. So this now gives in some additional importance to people who may have experience of a certain kind in a certain area, and there's been much debate on that. How do you then define minimum wages for somebody with 10 years of experience in a particular area or a trade, as opposed to somebody who's coming in newly? What then is the same work or work of similar nature? You'll see that the definition also includes the word responsibility. The government of Karnataka, for example, and some other employers in their recommendations to the standing committee have said that this is something that is very ambiguous. We don't know what responsibility really means, and this has to be further fleshed out. So we sort of see a lot of litigation around these sort of definitions as and when this code comes into force. Of course, what form it will come into force is a different thing. And similar working circumstances, throw in experience, all of these things will change. Wages itself, of course, is defined under the Act to mean all remuneration. And interestingly, it uses the word whether by way of salary, allowances, or otherwise, expressed in terms of money or capable of being so expressed. So this has the definition, and it also has the standard exclusions which exist in the current regime. Bonuses, as defined there, if allowances paid other than the dearness allowance exceeds 1/2 of the aggregate wages, the amount in excess of the 1/2 to be consolidated with the aggregate wages. So, this is sort of taking on the existing way of the Payment of Bonus Act. Interestingly, the idea that the existing Payment of Bonus Act requires that the payments be made in cash, and now this code sort of really pushes payments to be made through electronic forms or through bank accounts, pushing the whole objective of the digital economy. So that is a significant change, that sort of recurring theme that is coming up repeatedly under the bill. I'm now moving to the key concepts. You'll see these in terms of actually what the key concepts of the change that is proposed in terms of the national wage itself. The center has to fix this national minimum wage. This national minimum wage, as all of you probably know, labor and employment right now is in the concurrent list, which basically gives both the center and the state the sort of power to make rules and to make legislations on. So this has normally been something that each state determines in terms of what constitutes the minimum wage for that state. Sometimes there is an industry-specific requirement. For example, the railways or somebody else may have some sort of a specific minimum wage. What this new code looks to do is it seeks to fix a minimum wage which is at the national level. There is, of course, discretion that is given, which says that the wages can be fixed region-wise or state-wise. There is much criticism to say, what could work in say, Tripura would be very different from what would work in Maharashtra. What would work in Karnataka would be very different from, say, what would work in Jammu and Kashmir. So this sort of blanket national minimum wage may not really work. So the region-wise or state-wise is really the way to go. The states then get to fix minimum wages again for different areas, establishments, and nature of work. The state minimum wage cannot be lower than the national minimum wage. So, so there is sort of some overarching impact that this national minimum wage will have, unless, of course, it moves to the regional minimum wage. Minimum wage rates to be fixed on the basis of the time pieces. So it could be daily work, it could be monthly work, or for a piece of work. Of course, there is also the hourly aspect that continues to exist. Then there is a basic wage plus cost of living allowance that can be taken into account. And this is sort of with the larger standing committee report, which looks at the UN Sustainable Development Goals for 2020 and says keeping in sync with the cash value of concessions of essential commodities, and accordingly the national minimum wage would be fixed. Junaira?
Yeah. So when the state is fixing minimum wages, it can also provide for factors basis which the minimum wage fixed for a particular kind of established work will be multiplied, and these factors essentially would be the skills required to do work, or if a particular job is being done in a particular geographical location, or depending on the difficulty in working conditions or experience, etc. The minimum wages fixed can be multiplied. And while fixing minimum wages by time, the government can also fix maximum number of hours that would constitute a normal day, the standing committee report has suggested that they should not exceed 8 hours a day, but we're yet to hear what finally will be included in the code which will be introduced in the Lok Sabha. There also be a requirement to provide for a compulsory weekly off in a span of 7 days. There are certain exceptions also that the wage code contemplates with respect to your maximum number of hours in a day. These would include instances like urgent work which couldn't be foreseen, works which for a technical reason needed to be completed before the end of the workday, or work dependent on weather or natural forces, or preparatory or complementary work. However, the conditions that will apply and on what basis these exceptions will actually pan out is something that will be notified as per the notified in the due course. Another aspect is that under the wages code, the minimum wages is they've provided for revisions only once in an interval of every 5 years. This is actually different from what the current law provides. Minimum Wages Act currently provides for a flexibility to revise wages periodically with a requirement to do so once every 5 years, but this is kind of changed. But again, a lot of representation on with respect to this under the standing committee report, where they said that the flexibility to revise wages within the period of 5 years should remain, and you should not just hard code it at only intervals of 5 years. Moving on to discussing and understanding the proposed changes in the current law vis-à-vis the wages code. The first aspect is coverage. So under the Minimum Wages Act currently, it's fixed for only scheduled employments with more than 1,000 employees. And with respect to Payment of Wages Act, it applies only to employees whose wages do not exceed 24,000 a month. And for the Payment of Bonus Act, it applies to establishments which have more than 20 employees, and only for employees who earn less than 21,000 per month. This is undergoing a significant change under the wages code, where provisions relating to minimum wages and payment of wages will be applicable to all employees, irrespective of any wage or number threshold. Bonus provisions will be applicable, however, only if the wage threshold exceeds a particular amount which is yet to be notified, and it will be applicable to establishments who are having more than 20 employees. I'm sorry, there's a typo there. That will be more than 20 employees. Here there is an interesting aspect. So some states like Karnataka have notified that there would be establishments employing less than 20 employees would also be covered under the Bonus Act currently. So now we need to wait and watch how will this gap be covered when the wages code comes in. Whether they'll make an exception for these establishments having less than employees to be included, or how this is going to pan out.
The next slide talks about overtime wages. The Minimum Wages Act just says overtime wages are at rates fixed by the central or the appropriate government, which could be the state government. The new wages code clearly says that overtime should be at least twice the normal rate of wages for that prescribed amount. So it's calling out that overtime is very, very clearly a much higher payment that needs to be made. Employees working on a weekly off also to receive payment for such at an hourly rate for overtime. So again, sort of more labor friendly than what the existing law is. A normal work day based on what the standing committee report looks at constitutes about 8 hours. I have a question which asks for, does this period look at rest? No, the code is silent on whether there is a requirement of rest. that would go within these 8 hours, but I think normal working conditions would stipulate some period of rest, especially based on the kind of work that we're looking at. So that is something that sort of is a significant departure from the existing statutory framework in terms of overtime payment. The other question that's come up is, well, how do these codes play out in the context of the Shops and Establishments Acts in each state? I think when we interpret Shops and Establishments Act in sync with the existence of current labor law, we try and get a harmonious interpretation as much as possible. The code is silent on any references to the Shops and Establishments Act. So I think the Shops and Establishments Act will have to be interpreted harmoniously. We don't see how there could be any sort of a deviation from the code as such. So once it's notified, if there is a very apparent discrimination, it'll have to be brought in sync. So I think this is really looking only at wages and how payment of bonus issues. So that will have to be brought in sync. The slide that is now on your screen should be talking about gender discrimination. The Equal Remuneration Act is the one that said that there has to be payment of wages in the same form without any gender discrimination between men and women, and there has to be pay parity. The pay parity continues to exist under the wages code, but there has been some criticism to say that there is no provision under the new code which talks about how women can be hired, how in the case of recruitment and promotion, which the jurisprudence under the Equal Remuneration Act went beyond just remuneration and looked at other aspects of gender parity, which the wage code does not do. So that's one step back in terms of gender discrimination. There is also some critique to say that there is no discussion whatsoever in terms of LGBT rights. Especially there's been a lot of jurisprudence around transgender employment and non-discrimination on that front. So the code doesn't really touch that issue at all. We've had some research to show that after the maternity bill has been, the maternity issues have, the Benefit Act has been notified, the hiring of women has significantly come down. And this doesn't really sort of address that issue because, 6 months maternity leave, which has to be paid by the employers and not subsidized by the states, has meant that there are lesser women who are being hired. But this wage code really doesn't address that issue in any sense. Moving on, Junaira, you will have to look at fixation of wage periods.
So on slide 30, we're talking about fixation of the wage periods. So under the current laws, wage periods actually can be fixed at the discretion of the employer, while it's generally on a monthly or a daily basis, but there is the discretion that an employer has with respect to fixing wage periods. And payment timelines are essentially dependent on the type of establishment and the number of employees. Under the Payment of Wages Act, we have provisions to say that if you are employing less than 1,000, then generally the wages need to be paid within 7 days, and if it's more than 1,000 employees, then it is within 10 days of the succeeding month. Under the code now, there's a lot more clarity that has been introduced. Wage periods need to be fixed either on a daily, weekly, fortnightly, or a monthly basis, and payment timelines are also structured in a very have been structured. If it's a daily wage, then you have to pay wages at the end of the shift day. If it is weekly wage, your payments will have to be made on the last working day of the work week. If it is a fortnightly employment, in that case, you need to pay wages for the end of the fortnight. And if it's then wages will need to be paid within 7 days of the succeeding month. Moving on to aspects of payment of wages in cases of terminations and resignations on slide 14. One interesting aspect that has been introduced under the wages code is that you're required to, so under the current laws, you're required to pay wages within 2 days of cessation of employment, and cessation of employment is essentially limited only to terminations or closure of an establishment. But this has gone a step ahead and now being made applicable in case of resignations as well. What we need to bear in mind is that we do see cases where your full and final settlements are generally done within, say, 15 to 30 days of termination or resignation. But now with this being saying that it has to be paid within 2 days, something that we need to see how it pans out. On slide 15, where we're talking about payment of bonus and grounds of disqualification of payment of bonus. I mentioned upfront that earlier statutory bonus could be paid in cash. Now statutory bonuses need to be transferred to the bank account of an employee. And grounds of disqualification for receipt of statutory bonus under the current Bonus Act is limited to fraud or any violent righteous behavior within the establishment or any misappropriation of assets of the employer. Wages Code goes again a step forward and includes even conviction for sexual harassment offences as a ground for disqualification. Now, of course, again, we need to it's silent. It just talks about conviction for sexual harassment. We're not yet sure whether they're talking about conviction by a court or decisions taken by the management of the employer post recommendations from based on an ICC inquiry.
So there's a question here which asks that even in the context of resignation, is it just 2 days in terms of cessation of employment? I think cessation of employment, even in the context of resignation, is really finally when the person stops actually working for the organization. The point that we're making is under the current regime, resignation was not seen as a cause of separation. It was only termination or on account of closure of the establishment. So this, because of the wider net cast in terms of who is receiving wages, we're looking at resignation as well. 2 days from the time, it may not be immediately, the day the resignation is accepted, but the days when after negotiation parties say that, this is when employment actually ends. So 2 days is what the court talks about. Even currently it's 2 days, but it really, the point is that it's extending to resignation. There may be a 30-day notice period, there may be 6 months notice period. It depends on what kind of employee, or there may be even immediate acceptance if that is the issue. So I hope that answers the question that was raised. Moving on. On the issue of conviction for sexual harassment at the workplace, which has now been added as a ground for disqualification, I'm sure as everybody's aware, the whole departmental ICC inquiry is required to be kept confidential. And the actual act of termination of somebody who's been proven to have acted in a manner which comes within the realm of the Prevention of Sexual Harassment Act at the workplace is only taken by the person who has the right to actually terminate the person's qualifications from the employment on the roles of that organization. So therefore, conviction therefore stands from there. There is a possibility of appeal, but I think the word conviction really is looking at an internal label or perspective which could arise from the departmental inquiry. Of course, as Junaira said, the code is silent in terms of what constitutes conviction. The next 2 slides, we're really looking at procedural aspects of, who is an inspector under the current laws, and the new wage code really talks about facilitators. An inspector currently is vested with the powers to conduct surprise visits, examine persons and records of establishments, which I think the labor or compliance people will know that this happens quite regularly. The language that is used under the wages code is that of a facilitator. who has to be appointed by the appropriate government. And the facilitator then really looks at inspections, information requirements, compliance under the wage code. And this could also happen on the basis of a web-based inspection scheme, and there is sort of clear interaction between the employer and the employee, along with facilitators. This is sort of yet to be clarified in terms of how the facilitator would actually work. But as we've sort of felt that the surprise inspection visits that sort of have marked labor inspectors, in West coming down to different employers is sort of done away with under the new code. Looking at the offences and penalties that have been set out, the penalties obviously have been significantly enhanced. If you just look at the two comparative columns before you, you'll see that the penalty under the Minimum Wages Act was a penalty which could include fine up to 500 and imprisonment of up to 6 months. Whereas here it now goes up significantly, with punishable with a fine of up to 50,000 rupees, and repeat offences within 5 years can go up to 1 lakh fine or both. Obviously, as employers, we know that the penalty also bites, because the imprisonment and senior directors who are considered as employers, who are in control of the establishment, are subject to this fine and the possibility of imprisonment. That continues to be the case, because the definition of employer continues to be any person who's in control of the establishment, and therefore that extension could be any senior director who has knowledge or is required to comply with the wages code. The second aspect of the slide looks at non-payment of wages at specified time period, with a fine of 7,500, which now goes up to 20,000, and then 40,000. So there is definitely a significant enhancement. The definition of employer continues to bind senior management, and that is continues to be the case. Moving on to the next slide. Again, if I'm looking at Payment of Bonus Act and Equal Remuneration Act, they also stand enhanced based on what the Standing Committee recommendation has been. The idea is that this will act as a deterrent if this goes up to 10 lakhs, and the employer really is, again, senior directors or directors who are involved in the running of the establishment. Junaira, you want to look at records, returns, and notices?
Yeah. So we're on slide 19, where we'll be talking about records, returns, and notices. So under the current laws, it's scattered compliance across the 4 legislations. There are multiple registers that you need to maintain, as well as filings that need to be done. What is contemplated under the wages code is that there would be a single maintenance of a single register that would contain details of all the persons employed, the muster roll, as well as details of wage payments. And along with that, there would be the requirement to display on the notice board of the company a summary and an extract of the wages code, category-wise wage rates, wage periods for different categories of employees, date, time, and day of payment of wages, as well as the name and address of the facilitator, the jurisdictional facilitator for that establishment. There is also a provision which talks about an exception from the maintenance of the registers and display notices for establishments employing less than 5 persons, but only in the context of a domestic or agricultural establishment. In these cases, as essentially when we say this, they're referring to domestic, they would mean someone who's working in your house as a help. But in these cases, facilitators may actually demand proof for payment of wages to such persons employed in these contexts. Yeah.
So finally, we're just looking at the impact on employers, and how does it change our daily life, and does it really make a difference in terms of payment of wages? So if there is an unorganized sector that has an impact, yes, clearly this is now casting a a much wider scope in terms of compliance to a larger section of employees. The code is very clear that all kinds of establishments will now fall within the scope of the code, and the exclusions are very, very minimal. So therefore, this sort of national minimum wage will have to be paid out across establishments. There is also very clear documentation to say that contract labor will fall within the net of these requirements under the wage code, bringing contract workers also within the scheme of the wage code, because the contractor then becomes the principal employer who has to discharge payments in the same manner. Of course, if the contractor fails to do so, then we see that this continues to be an obligation on the principal employer as well. So that sort of segregation falls away in terms of payment. There's going to be a very clear definition of wages, which doesn't really restrict the Payment of Wages Act to a workman. The definition of employee, along with the definition of worker, really looks at a wide range of people who would probably include every kind of engagement in the country. There is a definite number of work hours that are required to be set out. Of course, as we discussed a little earlier, this has to be in consonance with the Shops and Establishments Act and the industrial standing orders in each state to make sure that there is compliance and synchronicity along this. So this is what we see really is a significant change that will impact employers and as also employees in terms of how they look at the wages code. The compliance and documentation really has to make sure that this is put in place once the wage code is notified. So these are some of the things that we think will have an impact. And of course, the significant issue is what will be the fixed minimum wage? Will it be a national minimum wage, or whether it be a regional minimum wage, which will actually make an impact in terms of the economics of running a business. That's really some of the things that we had to share. If you have any questions, please feel free to ask, and then we'll try and take this up along the way. The Payment of Gratuity Act does not belong to this code. This is really looking only at these four acts that exist. The Payment of Gratuity Act will fall under a different code, and we'll have to look at it as and when that comes up. But yes, I think there's also a question that says, is the gig economy part of this? Presumably it will. You know, people like Swiggy and Uber and all of these others who fall outside the scope of formal employment, the unorganized sector, the intention is very clear that everybody will have an impact along those lines. So yes, it will have an impact on them. Any other questions? We're happy to take. We have an audience here. If there are any questions, happy to take here. Junaira, did you want to add anything there?
No, thanks, Poornima. Just on the aspect on contractors, and actually contractors has been defined under the wages code. It means anyone who's providing contract labor to an establishment, and in fact the code, when they talk about employers, they specifically have included the concept of contractor, and this is actually for the first time that they've done that. So essentially, yeah, contractors and contract workers are clearly in the scope of the wages code.
And I guess when people employ people, you really have to look at, when you're looking at same work for the same kind, you also have to factor in experience when you determine minimum wage. And what responsibility means is also something that will have to be interpreted in each context. So all of this will determine what a person takes home and what is given out by the employer. Any questions? We will share the slides, yes. We have all your email IDs, so we'll share the slides. There are no other questions. You have our email ID. You could send those questions in. Otherwise, thank you very much. And thank you for being a patient audience. Thank you.
Thank you.